Good afternoon. Would you please state your name and profession?
My name is Frédéric Jenny, and I am an economist by training, but I've been dealing with economic issues and legal issues. I became a judge later on in my career, so I have both an economic background and a legal background.
And why did you initially specialize in competition economics?
It was not a very recent choice. I studied in the US. The business school where I was teaching in France sponsored my studies in the US, but said you have to learn something that you'll be able to teach when you come back. So that I could not study monetary economics, for example, which is not so useful in a business school. And I thought that competition economics was the closest thing that I could study that would be useful in a business school. And indeed, I've been teaching industrial organization and competition economics for a long time now.
So a sort of lucky coincidence for the competition community. Is green competition law, which everybody's talking about now, an inevitable development in your view? Or do you think that other areas of the law are much better suited to saving the planet?
The answer is both. First of all, competition law is not meant to fulfill policy objectives such as to have a green planet. So there are instruments which, at least theoretically, because when you look at the COP26, it's not obvious that the adequate instruments have been so effective, but they are, in principle, regulatory instruments which are better suited to achieve climate change and a green economy. But at the same time, the question is, should competition law take into consideration the externalities that markets may imply in the long term for climate change? And my answer to that would be yes, indeed. It is a question of allocation of resources, and therefore it should come into the picture. And we already have a few decisions by competition authorities dealing with that.
Okay, now a question that's a bit tricky, but is there a competition or competition law problem that nobody's talking about and you don't understand why? And if yes, what is it?
Yes, I think, I'm sure that there are many, but there's at least one that comes to my mind, which is competition authorities have had a tendency up to now to take a very short time view of in their analysis. I mean, they look at whether the prices are going to come up tomorrow, and they tend to discount claims that there will be economic progress due to an anti-competitive merger or an anti-competitive practice, because they say, well, it's too far too far removed in time. It is therefore highly speculative, and therefore I don't take it into consideration. I think that there are many reasons why this may not be a proper way to analyze competition issues, and that a focus which would have a longer time frame in mind might lead to very different results. And I can give you an example. You know that 2 years ago, I believe, the Justice Department opened an investigation against a number of automobile manufacturers who had negotiated an agreement with the University of California authorities about the fact that they would meet higher standards than what was required by the federal regulation in terms of CO2 emission. Okay. Now, there are two ways one can look at this. One can say, and which probably was implicit in the Department of Justice idea, well, I want to look at this agreement because it's going to increase the price of cars, because they are going to be more sophisticated and therefore less polluting cars. And this may be against the interests of consumers, or it may reduce their choices. Or you can look at, if you take a longer time period in mind, in your analysis, you can say, well, this is an agreement which is likely to decrease the cost of transportation or car transportation in California, and this is going to be good for consumers. So depending on whether you take the short-term view or longer-term view, you may come up with completely different results. So I think that this is an issue that should be discussed, because competition authorities don't justify that the time period that they have for their analysis should be the right one.
Okay, so maybe that's already connected to my next question, actually, because that would be, what is the one thing that every competition lawyer or academic should know about competition economics, and that we at competition law academics often get wrong?
I don't know if I have a direct answer to your question, but I would say that one thing that every competition lawyer should know is that you never win an argument on the basis of competition economics. You have to have economists, because they guide you in figuring out what is the theory of harm or what is the answer to the theory of harm. But what is enormously important is for the lawyers to be able to put in intuitive form those academic results. And that is the reason why in many jurisdictions, for example, economists don't testify. Lawyers testify about economics because they get the explanation from the economists, and they are able to put them in a form that will be understandable by judges or even competition authorities. So I think that this is a very important. The second thing, which is really important for lawyers and which they do tend to forget, is that you have to bring in the economists really early on in order to adjust your legal argument and your economic arguments. And many cases have been lost because the economist was saying one thing and the lawyer was saying something different because they didn't coordinate early enough in the case.
Okay, thank you so much. So a lot to bear in mind for the interaction also of competition law and competition economics, which is what we're also here to discuss in today's conversation series. So we're looking forward to speaking to you in a minute.